Mr. Speaker, I think that members in the House on both sides have now received some of the amendments that I would be wanting to speak on. In many cases, it's just a reordering of the sections, but in a couple of important ways, it has to do with questions of how we would want to move from having criminal offenses into questions of having our citizens who engage or want to engage in possession and smoking of cannabis do so. If we can turn to the bill, Mr. Speaker, as I said earlier, that had been circulated originally, there is the amendment number 3 in the bill that speaks to amendment of section 2. And this really, in the original act, the Parent Act, had to do with the interpretation section. In this, I'm hoping that members would note that I would recommend, when it comes to committee stage, that instead of speaking of public place first, I'd want to speak about supplying. So that supplying would be on the front page at the bottom, but now that becomes, the Act's amendment is section 2, and I would recommend that when we come to that point, that A, by replacing the definition of the word supplying as follows: supplying includes distributing, selling, or gifting. And this had to do in the Parent Act that is just improving the definition of supplying, because in the Parent Act, the Drugs Act, it only spoke to supplying as distributing. And that could be that if you supply it, you could say that you give somebody the controlled drug, and it gets away from any sort of questions of sale and so forth. So it's just making it more clear that supplying could mean distributing, it could mean selling or gifting, giving somebody cannabis as a gift. And then B is, again, inserting the following, and here I say in the correct alphabetical order. So alphabetical order, and I speak first of public place, and which includes an indoor or outdoor area, whether privately or publicly owned, to which the public has access by right or by invitation, expressed or implied, whether by payment of money or not, including, and here we list places that can be described as public places: A, all commercial, agricultural, and industrial zoned lands and properties; B, bars, drinking places, restaurants, and clubs all would be regarded as public places. C, tourist establishments, hotels, and guest houses. D, schools and all other educational institutions. And this, of course, is new to what had been circulated earlier. So now D would be schools and all other educational institutions. E, again inserted, hospitals, whether publicly or privately operated. F, churches or other religious establishments except as is permitted under the Act or any other law. And we'll see where that comes in later. G would be correctional facilities, whether publicly or privately operated. H, public transportation, buses, taxis, and so on. I, government offices. And J, other places or buildings of all types accessible to the public. We now introduce a definition called smoke into this amendment to the bill.
Remember, I don't usually do this, but for, I guess, clarification or my own edification, use within, say, a private vehicle. Don't mean to put you on a spot, but consideration has been given to that. Where does that fall?
You said use?
Within
what does use mean? Because the question is, we have now removed, first I push it back, we removed the term use and we are saying smoke. And we are determining what smoke is. For instance, you could eat a cake or something that has marijuana in it that would not be contravention of this act. But the smoke in a public place would then be a problem. Okay?
And within a private vehicle is considered a public place.
In a public place.
Okay, just my own question.
Smoke means to inhale. Well, it is a fine line that has to be determined, because your private vehicle, but as you say, is in a public location. And so when we look at what public place means, it doesn't say anything about a vehicle. And so I'm not certain that we can, but it is a fine line, because we're talking about public places. Smoke means to inhale, exhale, burn, combust, vaporize, or carry any lighted or heated device or pipe, or any other lighted or heated cannabis or cannabis product intended for inhalation, whether natural or synthetic, in any manner or in any form, and includes the use of an electronic smoking device that creates an aerosol or vapor in any manner or in any form, or the use of any orally used device for the purpose of circumventing the prohibition of smoking in a public place. I then look, Mr. Speaker, at section clause 4 here, which amends section 6 of the Drugs Act. And if you recall, section 6 of the Act is one of those sections that Mr. Maccabee got certain declarations from the court. The Act is amended in section 6. A, in subsection 4, by inserting after the existing words, subsection 1, the new words and to regulations made under this Act. This section 4 basically does some grammatical and other important cleaning up of the Act. A and B. B speaks to, in section 4, paragraph A, by deleting the word hexion, H-E-X-I-O-N, and replacing it with the expression heroin. A typographical error had been made in the original Act, and so we're just inserting heroin to replace hexion. That should not have been there. In C, in subsection 4, paragraph E, by replacing the words 15 grams of cannabis or cannabis resin and substituting the words 15 grams of cannabis or 5 grams of cannabis resin. The original Act spoke to 15 grams of cannabis and cannabis resin, but cannabis resin is a concentrated form of cannabis. So you use a lot more cannabis to get cannabis resin. And the relative strength of cannabis resin brings that we reduce it from 15 grams now to 5 grams. D, in subsection 6A, by replacing the expression colons and with the expression, and that becomes a semicolon. Section 6B, the period is added, is deleted and replaced with and this is a significant change in subsection F. A new subsection 6C is inserted and speaks to 6C, the accused shall identify the person from whom the controlled drug was taken. This was thought to be important because if somebody was found in possession of some form of cannabis, in whatever amount, they could say that they'd taken it from somebody and they were going to give it to the police, say. And the question is, we are now saying you need to say who you got that drug from. We look at section 5 of this amendment, and it amends amendment of Act by inserting section 6A, 6B, and 6C. So we are now inserting and replacing 6 with 3 subsections A, B, and C. The Act is amended by inserting immediately after section 6 the following new sections: 6A, 6B, and 6C. 6A says, Mr. Speaker, cannabis possession in public use. That should be in public. I would think that should be. The possession is just possession. And
public use.
and public use. That would be that. It should be and. No, it does say in 6B, cannabis use and public. So it uses 6B. 6A says, A, a person who has in possession 15 grams or less of cannabis or 5 grams of cannabis resin, 1, shall be allowed to retain possession of such cannabis. So, and 2, shall be issued with a fixed penalty notice for $50, or in default of payment, shall be liable to 10 hours of community service, or if you are in default of that community service, to imprisonment for 3 days. And here we are moving, Mr. Speaker, to change and accommodate the attitudes that we have in to cannabis smoke, cannabis use and possession. If you're found with it, you're not smoking it, you're not using it, a ticket will be given to you, just as though you have a parking violation, you get a ticket. It's not a criminal offense. You'll not be charged. You will not have that on a police record, a criminal record. But you're liable, or you're likely to get a notice from an officer saying that you can keep it, put it away, get out, move it away, and you get a notice that you then have to say you have to pay a fee, in this case of $50. If you say I'm not paying it, you say okay, you then have, as it was, a contempt of that thing, and you're liable to pay $50. And just like if you had a debt from courts and you don't pay the debt, you go to court and you spend a week in jail. And it could well be that is a contempt of court. It is not a criminal charge. It does not go on your record. You no longer offend the law. And so this is where we say we decriminalize the question of marijuana in small amounts. Community service shows our attitude to the use of marijuana. That now, instead of a ticket of $50, we now say, you say, I'm not paying it, I don't have it. We'll go clean up the beach or do some community service as allocated. It is not a sentence, but it is as it was in order to remove that stigma and that stamp that we have had, that attitude we are talking about. And there we come into the question of where we are constitutionally. And so we note that we said 10 hours community service. And community service could be a number of different ways that we will develop the regime, and the court or whoever it is will determine what types of community service we have. In B, on the other hand, if a person is found smoking cannabis or cannabis resin in any public place, and we have listed those public places that we don't expect anybody to be doing, out in public, you're not supposed to be smoking on 4th Street and blowing smoke in people's face. A person found smoking cannabis or cannabis resin in any public place, but not including a registered place of the Rastafarian faith. So, a Rastafarian tabernacle is a place of worship. We said before that a public place is a church. So, for instance, we don't want to exclude the fact that you could go to one of the churches and pull out a spliff and start smoking. Because you say you're free there. But the Rastafarian faith, we are saying, is exempted. In that place, in that tabernacle, there are places of worship. And as we develop regulations, as we interact with our committee and move forward, there will be events that they may have that apply for and they'll be exempt. And those things in the pursuance of pursuing their faith, their religious conscience. And so we feel that in doing so, we are now conforming to the order as established by His Lordship. So that if you're found smoking in any public place, not in a place of worship of the Rastafari, or in any other authorized by this Act, and any regulations made under this Act, you shall be issued with a fixed penalty. In this case, a notice, penalty notice of $1,000. Yeah, we tell you it's $50, but if you're smoking it, you could pay up to $1,000. Or, in default of payment, you're now liable to do 20 hours of community service in the same regime again. And if you decide in doing it, then will be considered a contempt of court, and we'll have the court then determine a penalty or a term of imprisonment of up to 5 days. Again, some may say these are lenient type of penalties, but the idea is attitudes in the country are changing as we meet and as we discuss. The society will determine how far we should go, and we expect that our core committee and others will assist us as we build out the major bill, cannabis bill, as we come forward and go forward. In 6B, we speak about cannabis use and public safety prohibitions. Again, I spent some time speaking about international conventions. Senator Phipps before me mentioned the question about public health and safety. And I'm sure that member for number 5 will speak about education and young people and safety provisions that has to protect the public. There are some people who don't want to have anybody next to them smoking in a public place or anything like that. And so therefore, whereas there are those who are moving that way and the society is accommodating that, we still have to have prohibitions for other members of the society. Remember that constitutional thing? For public health, for public order, there are certain provisos in relation to those freedoms that some people are demanding that they have. Sure, you can have them, but there are limits to your freedoms. Your freedom should not interfere with somebody else's freedom to public health and public safety. A, undertaking any task whilst under the influence of cannabis, if doing so would constitute negligence, professional malpractice, or professional misconduct, shall be liable to a fine of $20,000 or in default of payment to 300 hours of community service or in default to a term of 6 months imprisonment. Now this gets a little bit more now, because here now we talk about public safety. And this here trumps the question about personal freedoms and privacy and those type of stuff. You can't go to a doctor and he is impaired, or somebody driving a heavy piece of equipment and they're impaired, and they threaten the safety, the public safety of others. And so the state has to protect people in those conditions. It's not a free-for-all. So let me do as I like. You can't be going to work and you're all under the influence. Because now we say there must be protection. And so there is those public safety prohibitions that we maintain within the context of the new amendments. B, to have in his possession any cannabis on a school bus, on the premises of a school, or in a private residence that is used at any time to provide licensed child care or other similar social service care at that private residence, shall be liable to a fine of $30,000 or in default of a payment to a term of up to 3 years imprisonment. When it comes to the children, we should have no sort of leeway. It's very clear. The state has to protect the very young. And we cannot say because I have my own right to privacy or possession, whatever it is, that you can do it in front of children. That is a no-no. And we need to be firm and understand that whereas we move and we try to accommodate and have that balance in our society, there must be a protection for those vulnerable among us. And the very young are the most vulnerable of our society. And this prohibition, this here, is clearly, we believe, would easily be supported within our constitutional remit. C, now that is possession. So your own children and you got it possessed. Those terms there, but hear about it. Engaging in the use of cannabis on a school bus. And maybe when we come to actually go to committee, we'll change that word from use to smoke. It's cannabis on a school bus. Imagine a driver driving a school bus and he's puffing away at a spliff with school children in it. What would you say as a parent? On the premises of a school. Huh? My time has expired.
I know I interrupted you. So.
Yeah.
Take 2 minutes.
Thank you very much. Very quickly, but that is the tenor of these amendments. Operating a motor vehicle, engaging the use of cannabis at a private residence that is located 300 feet away from a school during regular hours. This, of course, was something that we had a very strong discussion about. And maybe 300 feet away might be too far. Because if I live in my house and I have a couple of blocks away, I'm not 300 feet away. Is it interfering with my privacy? I'm in my house and I'm 300 feet. It is something that we have to look at, and we welcome suggestions whether 300 feet are too far away. And these then are the prohibitions. Mr. Speaker, the last thing I want to very quickly mention, well, too quick if I can in my 2 minutes, has to do with 6C, treatment and programs for child offenders. Children, we understand, are smoking marijuana. And basically, if you're under the age of 18 years, we feel that you should not have any type of criminal charge, sealed even as it goes to the court, but that you should be facing counseling. Our schools have guidance counselors, and so there has to be training of them to introduce into the schools questions about use of marijuana and other drugs, or controlled drugs. And so that is what that does. And we say that under the provisions of the Child Justice Act, number 19 of 2013, where a person is found in possession of or engaged in the use of cannabis or cannabis resin is a child, he or she shall be required to participate in a drug counseling program approved by the minister. And finally, quickly, Mr. Speaker, amendment of Section 7 speaks to cultivation. Subject to subsection 1, a person may apply to the minister through the council for a license to cultivate cannabis for personal use and shall be guided by regulations made under this act. And it envisages that there will be a regime that will be developed for the drug council as it now exists within this act, the Drug Abuse Act, to be able to administer licenses within the regulations that are set up for it, that you should be able to cultivate a limited amount of cannabis plants in your house as we go forward. Again, the regulations still have to be done, but the discussion so far has been you can go up to 5 plants in your home. And so we speak to that in the regime, it responds, as we say, to questions of possession, to questions of supply, and questions of cultivation are handled in this bill. In the number 7 here, amendments to the second schedule, controlled drugs, what has been done here has been to explain in the schedule that establishes cannabis and cannabis resin as controlled drugs, the various ingredients of the cannabis, which, for a shortened word, are THC and CBD. These basically are the 2 components that are in the marijuana. THC is what makes you high. CBD is what is used by many in terms of the medical aspect of the marijuana. And CBD is now removed from the schedule as a dangerous drug. We have not removed THC, but CBD is now removed from the schedule as a dangerous drug. It's no longer there. And so it opens up the door for when we develop the medical use of marijuana, that it can be imported, it can be manufactured, it can be produced locally to be able to serve within the medical fraternity. And Mr. Speaker, my time is up.